Good evening, everyone. I was waiting for Wyatt to give me the nod, but as you all went silent, I took that as a sign. It's a great pleasure and a privilege for me to invite all of you, or to welcome all of you, to the Banco Court this evening for the second Mullenjaiwakka Lloyd McDermott Oration. A very special and warm welcome to Philippa McDermott, Mullenjaiwakka's daughter, who has travelled to be here with us tonight and who is going to do the acknowledgement to country for us.
Thank you, Chief Justice, and good evening, everybody. I am unexpectedly doing the acknowledgement of country tonight because Uncle Clegg couldn't make it. He sends his apologies. So, of course, firstly, I would like to acknowledge that we are here on beautiful Yagara and Turrbal country. I acknowledge elders past and present and our emerging leaders of the future, many of which are in this room tonight. I also acknowledge all of our elders because without them, of course, we wouldn't be here, and the journeys that they have had to bring us to where we are tonight. Of course, I'd also like to acknowledge Justice Louise Taylor. Absolutely thrilled that Louise could do the oration this year. Louise is a trailblazer like Dad, and we couldn't think of a more fitting person to do the oration, the Lloyd McDermott Mullenjaiwakka oration. Dad grew up on this country, of course, where Waka Waka and Mullenjaiwakka. My Mullenjaiwakka country is from Tweed Heads to Bow Desert. I've spent a lot of time here in Brisbane. My grandparents lived in Inala. I grew up between here and Sydney, and Tweed here, Tweed and Sydney. So I've been able to, spend a lot of time here in this beautiful country. And of course, I acknowledge my Mullenjaiwakka and Waka Waka family and connections as well. Also acknowledging all Indigenous people in the room and their cultural connection to their country and cultural authority that they bring with them, cultural authority over their land, waters, skies. And if I haven't seen you yet, I'll say hello to you afterwards. But thank you very much for coming tonight. That's an incredible turnout as well, with a packed house and all those people online as well. Hello out there. And I would just like to acknowledge from my family that we are absolutely humbled and honoured that you hold this oration and that you're all attending here tonight, and that we could have Louise be our keynote speaker. So thank you very much.
Thank you very much, Philippa. So, at its heart, the Mullenjaiwakka Lloyd McDermott oration has three goals. The first is to increase dialogue and raise awareness of current legal issues affecting First Nations peoples by providing a platform for leading First Nations voices in the law to educate the Queensland legal community. The second is to encourage appreciation and respect for the achievements of First Nations people in the law, including increasing the recognition of First Nations lawyers and the Indigenous Lawyers Association of Queensland. And the third is to establish a conversation amongst the Queensland legal community around law reform. Those present tonight might also like to consider contributing to the Bar Association's Mullenjaiwakka Trust. Like tonight's event, the Trust is named in honour of Mullenjaiwakka, and that Trust was launched in 2009 and was established for the relief of Indigenous persons in Australia for whom coming to the Queensland Bar is a primary career objective, and who have suffered some socio-economic disadvantage which may constitute an impediment to their pursuit of a career at the Queensland Bar. The Association, through that trust, offers applicants the opportunity to apply for financial assistance to cover expenses incurred in pursuing a career at the Queensland Bar. So I do encourage all of you who are able to contribute to the Trust. That is a tangible way in which you can encourage and foster increasing numbers of First Nations law students and legal practitioners to commence a practice at the bar, which in many circumstances is the avenue towards judicial appointment. It's an important thing to talk about increasing diversity within the judiciary, but that doesn't happen without encouraging people at those very early stages to study law and then to embark on legal practice, including at the bar. Now, it's my great pleasure to introduce the Honourable Justice Louise Taylor, who is delivering the Mullenjaiwakka Lloyd McDermott Oration this evening. Justice Taylor has asked me to be brief in my introductory remarks, but I'll just say that Her Honour is a Kamilaroi woman, born and raised on the lands of the Gadigal people and now living on Ngunnawal country. Her Honour's family hails from the New England region of New South Wales, including Walhallow, Quirindi and Baraba. Justice Taylor was sworn in as a judge of the Supreme Court of the Australian Capital Territory on 16 August 2023. However, Her Honour is a very much longer experienced judicial officer, having served previously as a magistrate and coroner of the Magistrates Court of the Australian Capital Territory from 2018. Her Honour is, as is well known, the first Aboriginal woman in Australia to be appointed a judge of a superior court. We are absolutely thrilled to have Justice Taylor here this evening and very much look forward to what she has to say.
I have a terrible fear that my pages will be out of order, so I was just double checking that they were all in place. I begin where I should, and that is by acknowledging that we gather here this evening on Aboriginal land. I acknowledge the contribution of the Yarraga and Turrbal people to this beautiful country, and I thank them for having me on their country today. Their people, our people, have survived a brutal colonisation. Sovereignty has never been ceded. This always was and always will be Aboriginal land. I extend my thanks to the Chief Justice for her generous hosting of this evening's event. And I also want to thank Chief Justice of the ACT, Lucy McCallum, for readily supporting my acceptance of the offer to deliver this oration tonight. In a small court of only 6 resident judges, accommodating the absence of one can be tricky, and Lucy did not hesitate to say yes. She does climb enormous rocks for fun with her bare hands, so I suppose managing a court roster pales in significance. I want to make special mention this evening of Joshua Kremer, who made the significant effort to attend my swearing-in ceremony in August last year. It is often the case that people will say, I hope to make it to those occasions, and life just gets in the way. And I certainly did not expect anyone to move their life around for what really is a bit of an indulgence. I was truly moved to see Josh in attendance that morning in all his robed magnificence. When I spoke to him at the ceremony, he made it clear to me that he thought himself there as a representative of our people in the law and that they were proud of me. And I still get emotional thinking about that, and I want to acknowledge Josh's kindness to me. Thank you all for coming this evening. I know it's hard to muster up the motivation to attend an event like this after a long day at work, and I'm grateful that you've all given your time up to be here. My sincere thanks to Wyatt Cook-Revel, who has organised me and patiently responded to my just one more question emails. Fellow judges, magistrates, friends, I begin tonight with a bit of a personal confession. While I have been excitedly anticipating this evening, I also have a sense of trepidation. It is indeed a thrill to give this oration in the name of a truly remarkable Aboriginal man. It is a rare opportunity that we are able to publicly acknowledge and celebrate Black excellence of the kind that Mullenjaiwakka represents. That Philippa would entrust me with the task of honouring her father means a great deal to me, and I can only hope to do the man justice. Thank you, Philippa. I'm nervous for a couple of reasons. First, because like Philippa, I am a daughter grieving her dad. I fear my grief in honouring a man who was, above all, like mine, an adored father, will reveal itself. And I hope you will forgive me if the grief that I feel I wear like a heavy cloak since my father's death last year comes through in some of my remarks this evening. Like Mullenjaiwakka, my father has an annual oration named in his honour. I gave it last year, some months after his death. It was an occasion that brought heartache as well as pride, feelings I imagined Philippa might be experiencing tonight. Our fathers were around the same vintage, very much Aboriginal men of their time. Men with a penchant for a moustache and fiercely committed to the struggle of our people. Anything I have said about my father is reflected in the things that I have read and the testimonials I have listened to, demonstrating your dad, Philippa, to be very much like mine. Gentlemanly and principled, hardworking and humble. These men, while men properly owned by our communities, were, at the end of each day, just our fathers. I have discovered that nothing can prepare us for the loss of the people who anchor us emotionally, culturally, and spiritually in this world. And I want to acknowledge the enormity of that loss for you and your family. My own father's death has left me with a feeling of vulnerability that I did not expect, as if a wall of protection against the world that I have constantly relied upon has been torn down, and I'm exposed in a way I've not ever been. To use a boxing analogy, I'm fighting without my trainer in my corner, and it feels quite strange. Mullenjaiwakka was a giant among our people, and his loss is keenly felt, never more so, though, I imagine, than around your dinner table. I'm so sorry for the loss of your dad, Philippa. Our heartache is matched only by our love for my sister, and I'm honoured this evening to speak in your dad's memory. I observe here, because it seems the right point to do so, that grief is an ever-present, pervasive presence across our communities as First Nations people, often in the tragic circumstances of our people dying preventable deaths too young. And I have no doubt that what feels like a disproportionate level of grief and the trauma that accompanies preventable death is a factor influencing our people's capacity to live full and happy lives. The second reason I'm nervous tonight relates to the constraints of judicial office. In preparing for tonight, I watched Tony's oration from last year, Tony McAvoy SC. I will come more to it later, but for the purposes of this part of my confession, Tony demonstrated the freedom that comes with being at the private bar, a silk no less, and being able to say what you like. Now, the difficulty for me, as someone who also quite likes to say what I like, is that I fear Tony's level of freedom may not be entirely available to me, at least if I would like to remain a judge. There are not many of us blackfella judicial officers, of course. Like any other judge, I can talk about the law, its operation, and areas for potential reform. But talking about legal issues particular to our people can never be, at least in my own experience, theoretical. I see the effects of those legal issues on our communities at every turn because I remain a part of our community. And as part of a First Nations community, I feel a sense of responsibility for the effect of the law, an idea I will return to later. As lawyers, we feel comfortable when there is a precedent. A precedent, of course, gives us some sense of what has come before and what might be tolerated in the future. But with so few of us appointed as judicial officers, It's hard to know exactly what the tolerance is or what the limits might be for a sitting Aboriginal judge to speak their mind. I guess we'll see. I don't think of myself as a judge in the sense that my thoughts on the world around me, and in particular the position of our people, are not developed through the prism of being a judge. My thoughts about the way the world works come about because I'm a Kamilaroi woman who happens to have a law degree. So in hindsight, now that I think about it, I probably should have suggested that Lincoln go first, and then I would happily line up next year after he set the precedent. But here I am. I've approached my remarks this evening on the basis that sometimes it's better to seek forgiveness than ask permission. I've been given some writing instructions for this oration, and I feel obliged to let you know what they are, lest you think that I'm a raging narcissist. Of course, this oration pays tribute to the enormous contribution, the legacy of Mullenjaiwakka, and in doing so seeks to highlight current legal issues affecting Aboriginal and Torres Strait Islander people. In addition, I've been asked to share my own story, dare I say it, my journey. If you're not on a journey, are you even living? That's another question. My journey to the law. I return, as I said I would, to Tony's version of this oration last year. There can be no doubt that it was made particularly powerful because of his deep personal connection with Mullenjaiwakka. The picture he painted of Mullenjaiwakka was made all the more compelling through the story of their friendship. You are deprived of that feature in my oration tonight because I did not have the pleasure of personally knowing Mullenjaiwakka. When I watched Tony so warmly reminisce about this man, I felt real sadness that I did not have a memory of a yarn or a war story to share with you this evening. I knew of him, of course, and I do have a family connection to him because my husband Joe, who will love that I am recording publicly that he had a talent for rugby union, was a beneficiary of Mullenjaiwakka's rugby union development team back in the day. A tremendous initiative aimed at encouraging and supporting First Nations rugby union talent. Joe was a Lloydie, as they are called, and speaks so highly of Mullenjaiwakka's contribution to rugby union, but more so to his exceptional personal qualities. But back to Tony's description of Mullenjaiwakka as a clever, kind, funny, humble barrister. A portrayal of a multifaceted man who exists in my mind as a giant. Some background to my life will give you some context for my perception of him. By the time I started high school, I had decided that I wanted to be a lawyer. My parents latched on to that aspiration. My mother, I think, because of course she wanted the best for her children, but also because, like many women of her generation, she'd not ever really been encouraged to follow her own dreams or fulfil her own potential. My father, because it coincided with his enrolment at university for the first time as a mature age student, having been the only person in his family to finish high school. Like Mullenjaiwakka, my dad knew education was the key to unlocking futures. And so when I expressed the thought that I might like to be a lawyer, my dad was keen to promote it. And in doing so, he planted the name of two people in my head, Lloyd McDermott and Pat O'Shane. Dad was desperate for me to know that there were blackfellow lawyers out there in the real world to aspire to, in the hope that I might maintain my ambition. I can recall him painstakingly explaining to me what an amazing achievement it was to be a barrister. A barrister, he told me, is the person you wanted turning up for you when you have to go to court. And Lloyd was the first one of us who had achieved that rank. For much of my life then, Mullenjaiwakka has featured in my mind as an almost heroic figure. To hear Tony speak of this heroic figure as a funny man, a humble man, a kind man, a man who quietly maintained his principles later in life as stridently as he seemed to proclaim them as a young man. Those things were all confirmation that my father was right to hold Mullenjaiwakka up to me as a person worthy of pursuit. When one looks at the story of Mullenjaiwakka's life, including that he did not attend school until he was 11, one can't help but wonder what led him to a life in the law. I suspect others might know the answer to that question, but not knowing him to ask, I am left to speculate. My research did not turn up a direct answer on the public record from the man himself. A man so extraordinarily talented on the sporting field could have carved out a place for himself in a sporting capacity, of that I have no doubt. But in what seems to me to be the typical fashion of Mullenjaiwakka, he found a path uniquely his own and set his sights on what is, fundamentally, a helping profession. That is not to take away from the ongoing influence Mullenjaiwakka had on making space in the Australian rugby community for First Nations players. That alone is remarkable. But Mullenjaiwakka was not going to rest on his rugby achievements. It's tempting to reason that the experience of definitively rejecting the racist poison prize of playing rugby union for Australia in South Africa must have played some part in setting him on the pathway to legal practice, and perhaps it did. But I can't help think Mullenjaiwakka's destiny always extended beyond the sporting field, with a mother and a father seemingly determined that he use his brain, and a level of personal integrity and principle that demanded a broader contribution to the position of our people. I'm often asked how it is that I decided on the law so early in my life. It was not due to any scholarly love of the law itself, I can tell you that. As a new high school student, I could not have told you the difference between a tort and a shortbread, but I knew that there was a language to learn that translated to power. I don't mean power in a self-important megalomaniac sense. I mean the kind of power that meant you knew with certainty the inquiries you had to answer when a police officer asked you a question, and you knew with certainty the questions that you could ignore. The power that came from knowing how a system operates. It was this kind of power that I was interested in acquiring. I spent much of my youth in inner city Sydney, in a small housing commission community where my father was born and where poverty was almost contagious. It was a place where if help was needed, it wasn't the police who were called, it was your neighbours. That said, in a neighbourhood like ours, there were plenty of opportunities to interact with police. I can recall a seething sense of anger observing the interactions the community did have with police. Interactions where it was obvious who had power and who did not. I was not a shy kid. I was mostly obnoxious, if I'm honest, the youngest child, certain of her place in the world. If I'd known what I might say to those police officers, even though we'd been well schooled to keep our lips zipped, I probably would not have hesitated to say it. So while my anger was born of fear, absolutely, I recognise it was also born of helplessness because I knew that I did not know the rules of engagement, and I had a strongly developed sense of what was fair and what was not. My childhood provided me with a window into a world where disadvantage for so many in our community was a permanent state of affairs. My parents at one point ran the small corner shop. It was a disaster because the nature of the community meant that the business ran on tick, on credit, and both my parents were terrible at asking customers, their mates, to settle up. My first experience of domestic violence was as a kid in this community, in the back room of the shop my parents ran. Not within my own family, luckily, not ever that, but it arose out of the need to help a neighbour. I have a vivid memory of watching my mother sitting on a lounge whispering with an auntie, a close neighbour. The auntie was quietly crying while my mother carefully picked peas out of her hair, one by one. Auntie's face and neck were an angry, hot, red colour. I was a sticky beak. I still am, I suppose, in a way I think all criminal lawyers are. And I learnt that Auntie's husband had thrown a hot pot of pea and ham soup at her, and she had fled to our house. My father asked if he should go up there and have a talk with him, and I remember thinking, well, this'll be good because Dad will sort him out. But the offer was quickly rejected by the women as only making it worse. Coffee was made, cigarettes were smoked, and Auntie eventually went home. I could not believe the uncle who made us kids laugh had done such a thing. After Auntie left, I remember my mother banging around in the kitchen, calling him a devil under her breath, and I remember being relieved by the display of my mother's anger. And I also remember that life just went on as if nothing had happened. I look back now and identify those experiences, those feelings in those memories, as instructive of my sense of what was right, what was justice. The knowledge of the effect of disadvantage, the experience of power wielded absolutely, and a desire to know how to stand up to it undoubtedly drove me to the law. My first job as a lawyer was state prosecuting. I spent almost 15 years on that side of the bar table, several of them as a specialist family violence prosecutor, before defence work beckoned at the Legal Aid Commission. Family violence prosecuting was particularly challenging, frustrating and satisfying work. Safety and accountability were honourable pursuits for a criminal justice intervention. Criminal defence work was equally challenging, frustrating and satisfying. My overwhelming impression after years at the bar table was of the significant limitations of the criminal law to effect meaningful change in the lives of those unwillingly drawn into it, either as victims of crime, witnesses to crime, or perpetrators of crime. Many aspects of the law have changed in my time as a lawyer. Law reform has seen the ugly practice of complainants having to lock eyes with their alleged perpetrators across the courtroom while giving evidence a thing of the past, and mental health challenges, I think, are now much better understood than they once were. Diversity within the profession itself has improved since I was admitted, in terms of gender and cultural background. These are all examples of commendable progress. One thing that has not changed since I began practicing is the appalling rates at which First Nations children are removed from their families, First Nations young people are held in detention, and First Nations adults are incarcerated. The scandalous statistics have, for the most part, not moved in the time that I have been a lawyer. And if there is anyone left in this country who does not think that the rates of removal of our jarjums, our children, is not tightly entangled with the disproportionate number of our people in prisons, then I have a bridge to sell them. It's my observation after many years of practice and several years now as a judicial officer that unless we get the approach right in child protection and youth justice, we are simply creating apprenticeships for adult offending in both spaces. Some numbers to set the scene. In the 27 years since the Bringing Them Home report and 16 years since the National Apology, First Nations children remain more than 10 times more likely than non-Indigenous children to be removed from their families. In June 2023, almost 44% of children in out-of-home care were First Nations children, an increase of almost 4% since 2019. Our children account for 6% of the total population of young people under 17 years of age in this country. As at June 2023, First Nations adult prisoners accounted for 33% of the prison population, with 78% of them return prisoners. That statistic is best understood by reference to First Nations people accounting to around 3.8% of the total Australian population. To echo a sentiment of the Uluru Statement from the Heart, we are not an innately criminal people. The 2017 Australian Law Reform Commission Pathways to Justice inquiry into the incarceration rate of Aboriginal and Torres Strait Islander peoples makes for depressing reading. In particular, the chapter on child protection and adult incarceration lays bare the point I am seeking to make. The connection between children in out-of-home care, the juvenile justice system and the criminal justice system is almost as reliable as night following day. That we persist with the same approaches continually expecting a different outcome is quite simply madness. The sensible suggestion contained in that report of a national review of out-of-home care systems across the country, with a particular focus on assessing the most effective use of resources, has not ever been taken up. If only there were a national representative body made up of our people who were tasked with advising government on our own affairs who might prosecute this issue. Sort of like a collective voice for our people. The criminal justice system, I know, is asked to solve a great many wicked problems, often without the resources or the expertise to do so. And often we are trying to solve problems so deeply entrenched as to require a miracle for reform. And miracles are few and far between. The community understandably has high expectations of those of us sitting in judgment, and I don't shrink from those expectations. I do wonder, though, whether they are similarly high expectations for the experience of our children in out-of-home care. I say this having prosecuted parents who have had their children removed, only to go on and deal with those children, first in the children's court as young offenders, then in the magistrate's court for less serious crime, and now dealing with them in the Supreme Court for more serious offending. The preponderance of adult offenders with criminal histories that begin coincidental to their removal from their families, who then have horrific stories of abuse and neglect in the care of the state, continues to shock me. Perhaps it's a bit Pollyanna of me, but if children are removed because of concerns that they are not being appropriately cared for, that removal should not see them worse off, should it? If children are being removed from a situation that is harming their future should not look worse in the state's care, should it? The discussion around young offenders, the age of criminal responsibility and community safety, I acknowledge, is fraught. That many young offenders have a background of child protection engagement, including long periods in out-of-home care, begs the question, what standard of care do we expect and demand from the state as parents of those children? Add in privatisation of that state parental responsibility and accountability begins to look murky. And if the state is the better parent, how is it these young people are not better off in state care? I don't purport to know all the solutions to what I know are complex questions, nor do I pretend that the management of risk when it relates to the lives of little people is not incredibly challenging. But I do know this: unless we confront the abject failure of the approach taken to child protection for our people, we will continue to see those children march with certainty from the doors of the Child Protection Office to the in-custody doors in courtrooms across the country. While ever we don't address the reality of this established connection, the statistics will not ever shift in our favour. There is a related matter I must acknowledge about the position of First Nations women, and it's fitting I do so, I think, as it's clear to me, confirmed by Philippa, that Mullenjaiwakka, in the great tradition of the best of Aboriginal men, was a feminist. How could he not be, surrounded by women at home, his wife and 2 daughters, and his mother instrumental in his opportunity for success? And of course, the Lloydies is not just for First Nations men, but has been key to encouraging First Nations women with talent on the rugby field. I feel very confident that Mullenjaiwakka would support some particular focus in this oration on his First Nations sisters. Some estimates have First Nations women as 21 times more likely to be imprisoned than non-Indigenous women, and representing around a third of the total female population, prison population. It is well known that we are much more likely to be victims of violence, including homicide. And it's against the background of those facts that I observe it to be my direct experience that First Nations women are punished for a perceived failure by them to take responsibility for the violence perpetrated against them by the systems who should be working to protect them. The child protection regime, for instance, will often quietly demand that women, victims of violence, take out an order against their alleged perpetrator or risk being labelled not protective and having their children removed. As recently as last week, I heard of a case where a First Nations woman complainant was arrested on a warrant and held in custody for a period after failing to attend court to give evidence in family violence proceedings. Of course, those of us who have worked at the coalface of these systems know that the complexities involved for our women, for First Nations women in these situations, rarely make for straightforward cases. And for First Nations women, the added layer of deep mistrust of mainstream systems, institutions, and organisations is very poorly understood or accommodated by systems that have boxes that need to be ticked. This distrust is a direct reflection of the racism and oppression experienced by our people. There is some reluctance, I think, to acknowledge the acutely debilitating impact the experience of racism has on a person's confidence, capacity, and willingness to engage with mainstream institutions and organisations. Add to that modern-day experience of racism the inherited legacy of oppression, and it's naive at best to expect our women to make personal, intimate sometimes, disclosures to systems that have historically been the face of that oppression. Inquiry after inquiry has revealed that modern-day experience of racism is more than just our perception. Consistently, the systems First Nations women are required to engage in are exposed as having internal cultures overtly hostile to us as a people. Recent examples here in Queensland and in the Northern Territory make for uncomfortable consideration. In 2022, the Queensland Commission of Inquiry into Police responses to domestic and family violence observed this. Evidence provided to the Commission shows that the intergenerational distrust and fear of police experienced by First Nations peoples is compounded by contemporary, repeated, and ongoing experiences of negative interactions with police. Research suggests that due to a lack of cultural safety, police are not always perceived as a safe avenue of assistance for First Nations victim survivors. This is exacerbated by a range of factors, including a mistrust of police, fear of child removal and child safety intervention, fear of death in custody risks for the perpetrator, and other systemic barriers. As recently as Friday, ABC News reported that the Northern Territory Independent Commissioner Against Corruption has determined that new evidence collected arising from allegations of racism within the Northern Territory Police Force was too offensive for public release. I will let others judge the effect these kinds of revelations might have on the confidence of First Nations people in the Northern Territory to interact with a police force now empowered to impose a snap curfew upon their young people. The kind of complexities that I have attempted to capture, unique, I think, to First Nations women in many respects, are rarely given voice in the national discussion about violence against women, and they make the case for specialist services and advocacy for us to ensure that the needs and interests of First Nations women and children are properly met. It is, I think, one of the great shames of the failure of the referendum last year. Within the design feature of the voice was a requirement for there to be an equal number of men and women, an opportunity for the interests of First Nations women to be represented at a national level equally. Last week, I had the pleasure of listening to Cobble Cobble woman, Professor Megan Davis, reflect on the referendum failure. She astutely observed, among many other things, that the voice to Parliament was an opportunity to showcase First Nations women as leaders and for us to be able to speak for ourselves on the issues that affect us as First Nations women. As it stands in the current national discussion on addressing violence against women, First Nations women, expert in our own affairs, must elbow our way to the front, lest our interests and concerns be left off the agenda. That view confirmed with the recent announcement that the National Commissioner for Family Violence, Michaela Cronin, will chair a national rapid review panel that does not include an Aboriginal woman as a member. Which brings me, I think, to something I must do, and that is to acknowledge my own personal dilemma in the context of the institutions and systems of which I am critical. For some time now, I have obviously had direct involvement in the systems incarcerating our people and removing our children at the rates I've recorded. My involvement, I know, is difficult for some of our mob to reconcile, and I understand that difficulty, and indeed, if I am honest, I wrestle with it regularly. In preparing this oration, I reflected on what Mullenjaiwakka might make of it, and I came across this quote from him. "No one really knows the plight of an Aborigine. The most sensitive white person cannot put himself in the shoes of a black person. The prejudices are so widespread and ingrained that Aborigines have felt like aliens. To be as good as the next person, you had to beat him at school or beat him at sport. In other words, you had to run twice as fast to be his equal." Mullenjaiwakka captured two perspectives there that I think speak to my own experience. The first helps to resolve the personal dilemma that I have identified, and it is the importance of being inside the tent. It is critical that the lived experience of Aboriginal people is represented in the legal system so that it authentically reflects the society it serves. The devastating, unique impact of the law on our people must be truly understood by decision makers in positions of influence within the system so that it can be properly addressed. I am, of course, a judge for all manner of people. I am also a Kamilaroi woman. The statistics of which I have spoken are not just numbers to me. They tell the stories of our families, of our communities. It makes sense to me that our people must participate as more than just subjects in the legal system foisted upon us. Our participation as lawyers and as decision makers enriches the understanding of our people in the eyes of the law and enhances the capacity for the delivery of individualised justice. After all, systems of law are entirely familiar to our people. As eminent Aboriginal scholar Marcia Langton in her work with Aaron Corn observes, the idea of law in Indigenous societies, while remaining a system of rules for social good, also includes the idea of the English word culture. Beyond this, it also captures the idea of proper practice, the correct way of living a good life, as passed down by our ancestors over many generations, and the idea of the way, the path through life shown by ancestors who have gone before. The case for being inside the tent or on the bench is a good one, I think, but it doesn't mean it is always easy. I do take significant strength from the pride taken in my appointment and the appointment of others by so many of our mob, including some who have appeared before me in my courtroom. That pride reinforces the need for us to be in decision-making roles across the many sectors that influence our lives. The second perspective Mullenjaiwakka touched upon in the quote I referenced revisits a theme from Tony's Oration last year. It's a theme that resonates in both areas of Mullenjaiwakka's achievements, rugby and the law, and it's all about numbers and merit. Only 14 First Nations rugby union players have played for the Wallabies since 1938, in case you've ever wondered about it. There's much to be said about that figure that I neither have the time nor the expertise to dissect. On any view, the figure is ridiculously low. As Tony passionately outlined in his remarks as part of this oration last year, the number of us at the bar and on the bench is similarly low, and the speed of increase is at a glacial pace. That is not to take away from the achievement of those of us who are there, but it is to acknowledge that our appointments are not representative of collective improvement. It requires, as Tony touched upon when he visited this theme last year in his oration, about which I agree, it requires an interrogation of the concept of merit. The law has long perpetuated the fairy tale that merit has been responsible for each and every elevation to the bench, as if it is a mere coincidence that members of the judiciary have all attended the same kind of school and all look or sound a particular way. These coincidences are not criticisms of individual judges, but rather reveal a judiciary that might not reflect the broad life experience of the community it serves. We seem to have accepted now that the concept of the reasonable man should also include the reasonable woman. We must, I think, challenge ourselves to ensure that the law has the capacity to reflect the reasonable person in all their reasonable variations. The requirement for a sophisticated knowledge of the law to be a member of the judiciary is a given. But the suggestion that only a particular kind of lawyer with a particular kind of career and a particular kind of life experience can possess that knowledge can no longer be maintained. The Australian Law Reform Commission made this observation in their 2021 report without fear or favour, Judicial Impartiality and the Law of Bias. It has been repeatedly recognised that for much of its history, the Australian judiciary has been highly homogenous, comprising largely white, middle-aged Christian males from privileged socioeconomic backgrounds following similar career trajectories. This is not what contemporary Australia looks like. The Honourable Justice Mason noted how in the last century there have been different phases of attention on diversity within the judiciary. Yesterday's concerns, His Honour noted, were about Roman Catholic Protestant balance. More recently, following significant attention on the lack of gender diversity, more women have been appointed to the bench. However, women are still not on the bench in numbers that reflect the population. And other cross-cutting types of diversity, including Aboriginal and Torres Strait Islander peoples and people of other ethnic and cultural backgrounds, are very poorly represented, even when individuals from those groups make up a significant proportion of the legal profession. The report goes on to conclude, a range of strategies are needed to identify and address barriers to judicial appointment. However, from the perspective of judicial impartiality, more transparently impartial judicial appointments and the procedures that widen the pool of potential appointees and actively promote diversity in the judiciary without compromising the principle of merit selection are a critical step. In terms of diversity deficits, stakeholders have identified the appointment of Aboriginal and Torres Strait Islander people, people from culturally diverse backgrounds, and continued improvements in the rate of the appointment of women as key priorities. The case for diversity on the bench is effectively explored, I think, by some of the judgment rewriting projects undertaken by scholars in an effort to demonstrate and explore how different perspectives operate to influence the reasoning and outcome of judicial decisions. There are examples of this work from a feminist perspective, of course, and more recently from the perspective of First Nations peoples in Australia. In a legal system where we judges are invited to consider our own concepts of common sense and draw upon our own life experience to assess and evaluate evidence, is the system inadvertently skewed to favour a particular kind of life experience and common sense? The outcome of judgment rewriting projects may be instructive of that proposition, though I acknowledge that in some instances the benefit of hindsight and gradual shifts in accepted cultural norms may have some effect in the rewrite. Editors of the Indigenous Legal Judgments Project, Associate Professor Watson and Professor Douglas, have explained how some participants in the project, by reconstructing facts through First Nations eyes, identified not only that which was included in the original judgment, but significantly that which was missing from the original judgment. In this way, the original judgments were a record of the stories that were privileged in the judicial reasoning process, with the rewrites revealing assumptions made about the notion of relevance and ideas of expertise. When Mullenjaiwakka spoke of having to run twice as fast to be equal, it occurred to me that his perception about that can manifest in two ways. First, in terms of the assessment made of us by others, and second, the assessment we make of ourselves as First Nations people. The assessment made of us by others is where concepts of merit that I have just discussed play out. The assessment we make of ourselves is where we have more control. In many instances over the course of my legal career, I have felt a bit like a tourist in the profession. It might sound strange to you, I know, but regularly being the only blackfella in the room can have that effect. Of course, you learn to move around in the world, bracing for the consequence of that experience, and over time you develop ways of responding. But it would be artificial not to acknowledge the additional emotional and psychological labour that First Nations people take on when we move around in mainstream institutions and other places where it is essential for us to be. At my swearing-in ceremony last year, I was conscious that there were a number of new First Nations lawyers in the courtroom, and I wanted to speak directly to them. And if there are any in the room tonight, this is for your benefit as well. I said this to them: even when you feel like a tourist in the profession, you must carry yourself as if you belong, because you do. The hallways of judicial office must include us. For it to be otherwise is to deny the modern makeup of Australian society. The increasing number of First Nations lawyers confirms that we are no longer visitors to the profession. So too the small number of us on the bench as magistrates and judges across the country. Mullenjaiwakka, I am certain, did not become the first in the hope that he would be the last. Our presence at the bar table and on the bench is critical to ensuring that we have influence, as we must, over the effects of the law on our families and our communities. I wrap up this evening contemplating the future for our people. The failure of the referendum last year, in my view, represented a crushing blow to the simple and modest aspiration that nothing about us should be without us. Professor Davis last week recorded that in the aftermath of the referendum, it had been observed to her that no longer could this country blame the exclusion of our people from the Constitution on old, long-dead white men. Of course, I acknowledge that not all of our mob were supporters of the voice to Parliament, but the voting record reveals that for most of us, it was an unequivocal yes. The yes from our people speaks, I think, to the deep desire to be listened to and not just heard. What the Uluru Statement from the Heart characterised as the torment of our powerlessness. And so, in the face of the hard no from much of the country, where to now? Just yesterday, an elder from my community in Canberra said of the apparent chilling effect of the failed referendum. And if I could do her voice, I would, but I can't. She said this: well, they started it, they have to finish it. They can't just put it in a drawer now and pretend like it didn't happen. What's next? The answer to that question for many, I know, is treaty. Until this country deals with the original grievance of our people, exposed finally and for all to see in Mabo number 2, I fear the torment of our powerlessness will continue. And if this country could not support what was, at the end of the day, an advisory body, I just cannot see a clear way to treaty in the immediate future. What is clear to me is that there is a sense that we are not in control of our own destinies, and for any progress to be made against the indicators that reflect the day-to-day lives of our people, that must change. Treaty may well be where we end up, but it will not happen tomorrow, next year, or the one after that. And in the meantime, the statistics reveal the extent of the work to be done. Leadership that is visionary and unifying might see that work begin in earnest, but in light of the emphatic no, I would suggest that it will require real courage. The kind of courage that saw Mullenjaiwakka say no to a racist rugby game and walk tall in the hallways of justice when he was the only one of us there. Mullenjaiwakka was, I think, a realist, but a man who loved jazz music must have also had an imagination. Our ability to imagine a better future for our children has been the lifeblood of the resistance of our ancestors and a driver of our consistent demand for self-determination. Mullenjaiwakka realised the kind of future his parents imagined him capable of, and he stands as an example to us all of what hard work, self-belief and opportunity make possible. Most significantly though, Mullenjaiwakka is a compelling example of the power that comes from being unapologetic about who you are and uncompromising about what you stand for. He was in the courtroom as he was on the rugby field. Mullenjaiwakka, Mullenjali and Waka Waka man, an advocate for justice and an inspiration to so many. Mullenjaiwakka made the case, he set the precedent for the rest of us to follow. And for that, I am so very grateful. Thank you so much for coming this evening.
Chief Justice, judicial officers, distinguished guests, ladies and gentlemen, I'm deeply honoured to stand before you as the President of the Indigenous Lawyers Association of Queensland on behalf of the Management Committee. It is with profound gratitude I extend our heartfelt thanks to everyone who has contributed in making this year's Mullenjaiwakka Lloyd McDermott Oration an outstanding event. First and foremost, we extend our deepest appreciation to our distinguished guest speaker, the Honourable Justice Louise Taylor. Your presence tonight is a tremendous honour. Your insightful and inspiring oration has enriched us all, and your steadfast commitment to justice and to the advancement of Indigenous rights has left a lasting impact on our legal community, and we are truly grateful for your significant contribution tonight. Our sincere thanks goes to Philippa McDermott, the daughter of the late Mullenjaiwakka. Your support in allowing us, I can't see her, there she is. Your support in allowing us to honour your father's legacy through this oration is invaluable. Mullenjaiwakka's pioneering achievements as Australia's first Indigenous barrister and his remarkable contributions to the legal profession continue to inspire us all. We deeply appreciate the privilege of commemorating his legacy with your family's consent. We also extend our heartfelt thanks to the Honourable Helen Bowskill, Chief Justice of Queensland, for graciously again hosting the event in the esteemed Banco Court. Your unwavering support for Indigenous rights and your dedication to ensuring justice for all Queenslanders are truly commendable. Your presence here underscores the significance of this occasion, and we're immensely grateful for your support. I'd also like to extend our gratitudes to the generous event sponsors whose support have made the oration possible, to our major sponsors Landon and Rogers, QUT Law, P&E Law and Queensland Law Society. Your commitment to fostering diversity and inclusivity in the legal profession is admirable, and we sincerely appreciate your contributions. Our minor sponsors, Everett Heritage, Barry Nielsen, Parallax Legal, Minter Ellison, UQTC Burn School of Law, Ashurst, Wilberforce Chambers and the Bar Association of Queensland's Mullenjaiwakka Trust. Your support has been crucial to the success of this oration, and we're deeply grateful for your partnership and our mission for a more just and equitable society. Lastly, and certainly not least, I want to thank every one of you here tonight. Your participation in this oration signifies a shared commitment to advancing Indigenous rights and encouraging meaningful dialogue and pursuing positive change. Your presence here exemplifies the power of unity, and we are honoured to have you join us in this important endeavour. In closing, let us carry forward the spirit of this oration in the spirit of inclusivity, recognition and empowerment. Together we can build a future where justice knows no bounds and where Mullenjaiwakka's legacy continues to inspire those dedicated to the pursuit of justice for all. The Honourable Justice Lincoln Crowley said it best. In the end, justice is what it's all about, always was and always will be. Thank you.